Everybody to sales meeting. Let's see, I hope more people hop on today. It's kind of that summertime of the month, of the year, where people go travel and take their kids on, it's summertime, right? Go to a water park. So things are a little sparse right now, but let's get right into our announcements. Does anybody have any wants or needs they want to talk about this morning? Buyers, sellers, anything like that they want to bring up? If so, you can unmute yourself now. Okay, I don't hear anybody. So we're going to move on. Let's talk about our broker moment. Always, Presidio agents are always trying to raise the bar. So a thought that we had the other day was to turn your buyer broker into a checklist. It's not just a form that you send out to your clients to sign so that you can get paid. So we really want you to keep that mentality. There is a checklist. Keep it as a checklist. And I just kind of put a little bit over here on the actual list because they just updated it. They added a few more things. And so the reason why we're asking why is this a good idea, good practice to make you raise the bar, is because of a couple things that we've seen. So I'm just going to tell you real quick 3 stories. One, a buyer bought a home or was under contract. Actually, no, they closed, and they did not know that they were in a flood zone, which made their insurance a lot higher. And so it's one of those things that if you're going through, you could say to your clients at that time, hey, this is your due diligence. Have you talked to an insurance company? And again, we own White Knight Insurance. So that's a great opportunity for you to say, make sure you call an insurance company and make sure you know that it isn't in a flood zone. Talk to your title company that's not in a flood zone. And the other story is we just had a buyer try to buy a property that the week before closing found out that it was not insurable because it had tube and knob electrical wires in it. Not a single insurance company we could find would insure it. So how do you close on a property you can't have insurance on? You really pretty much can't, right? Lenders, unless it's cash, a lender's not going to have a loan without insurance on it. So this is why having a due diligence checklist and go through, hey, have you checked out to make sure you're in the flood zone? And if you are, have you checked out how much more insurance that is? Because sometimes people are really tight with their payment in terms of like, hey, I only have another extra $250 a month. Otherwise, I can't afford this home. And if the insurance is twice as much, that won't work for them. Also, one of the things that they updated is the HOA, the opportunity to find out about the HOA. Right now, I'm sure all of you have had these stories where there are HOAs and then there's a master HOA. So there's 2 different payments that the buyer pays for. And sometimes they don't disclose that on the MLS. And so again, use this as a checklist, go through and say, have you talked to your title company? Have you talked to the HOA? Do you understand that there could be 1 or 2 HOAs that you'd be paying money to? And what those rules might be. So again, in raising the bar, we want you to use that as a checklist. All right, you guys, any thoughts or comments on that? Okay, I'm glad we're getting some people coming in. This is our upcoming classes for the week. We're going to try and slow down on Thursdays because of the summer, obviously, but we do have a class next Thursday scheduled. So anyway, these are classes for next week. We have 5-hour CE next week. So please hop on and get your CE. And you can find that on our back-end website and on our front-end website. All right. Congratulations to our closers of the week. We had 65 closings as a company. Look at all those closings. If anybody's on here, way to go. That's so awesome. Good work, everybody. All right, also we had a capper was Ashley White in the Cedar City office. She capped out. That's a huge goal to get to. Congratulations, Ashley. Okay, our announcements this week, we do have a candy jar contest at the Pleasant Grove office. We have a picture of it on our Facebook page, so you can guess how much candy is in there, and just go ahead and send your email to presidioassistant@gmail.com. That's Casey, and the closest winner wins the jar of candy. So you might as well throw a guess over, right? So send her an email. All right, let's get to our affiliates. So Jack Andrews, I saw you on there. Please take a second and tell us a little bit about what's going on with Edge.
Well, thanks, Jen. A number of things that I want to underscore. First, Edge Homes continues, always has, and I'm told always will pay a 3% buyer's agent commission on full purchase price, which is lot, home, upgrade options, any over ask, stuff like that. So that's number one, and we want that message to be shouted from the rooftops. Secondly, we will lock in your pricing, no renegotiation of pricing at four-way or a week before closing, or we don't do any build cost or cost plus approach. We also don't have any no cause termination clause. So the only way we will terminate a contract is if the buyer is in breach. So nothing has changed for Edge Homes during these times. It's been an amazing thing to hear and see the internal discussions and their determination to keep that. Secondly, I am beginning to see offers kind of temper and slow down. Like Jen was saying, it's summertime, people are out and about. If you have owner-occupied buyers, there is availability across all product types. Condos, townhomes, single family. We have releases on Tuesday, Wednesday, and Friday. Call me if you would like to know the process on that. It is a very simple thing to be able to put in an offer. It takes about 5 minutes. And I look forward to helping you. Reach out to me for anything Edge Homes. Don't waste a second on the MLS. Disregard the listing agent on there because those are randomly assigned, and just call me.
Awesome. Thank you, Jack. I appreciate that. And is Amy White on? I didn't see at White Knight Insurance. Amy at White Knight, sorry. Amy Corcoran, no? Okay. Then we'll move on to Pat at HWA.
Thanks, Jen. So, hey, despite what Jack said about things slowing down, those numbers for closings last week, Jen, don't indicate that's the case at all. So congrats as a team, that's killing it. Hey, I just wanted to add some additional value to the services you guys already provide. So every time a warranty claim is filed and completed, I get an email. And you know who else gets that email? Is you, the realtor. The realtor gets this email that says, hey, great news, HWA saved your client's money. And this one here just addresses the realtor by name and says, we're happy to inform you that we recently serviced kitchen refrigerator with ice maker for your client. And it names the client and the property address. This one was in Mapleton. As a result, your client saved $1,134. Thank you for, again, for choosing Home Warranty of America and your client's protection needs. So it provides a phone number. The point to this email is that you are involved. You are constantly being branded as the realtor in charge. So when your clients have their claims serviced and completed, you're being notified of that. So you can reach out to them and say, hey, saw you saved money on your home warranty claim. There's lots of things you can kind of network with that. The bottom line is your clients are seeing your name in our services that they provide, and hopefully that'll generate new referrals for you from them as well. And so just wanted to, just kind of, address the elephant in the room. I'm not getting 57 orders a week from you guys. So, hey, if it's good enough for Jen, it's good enough for me. And you know what? We're a national company. We are backed by a $42 billion energy company. We pay our claims. Over 95% of claims filed get paid out. The few that don't, I sometimes get involved in those, and I can do favor budget with that. I can overwrite them and get them approved. So trust me, just give me a chance to earn your business. I really appreciate you guys. Thanks, Jen.
Awesome. Thank you so much. Yes, I know everybody needs to order listing home warranties, and then these guys are fantastic. I highly recommend them. So get your home warranties orders through HWA. They are our preferred. They sponsor us on everything. So please, please, please take good care of them. They take great care of us. So, all right, we are moving on to Braxton or Paul at Lunetta Home Loans. Are you guys on? I've not seen anybody there. Okay, we're going to move on to our educator of the day, which is Travis Jensen, and he is teaching surveying meets and bounds. And you guys, as much as you don't think this is going to be interesting, I promise it's going to be amazing. I already watched a lot of this, and it was so interesting. So you're going to love it. You guys are muted, just so you know.
All right, sounds good. Thank you, Jen. We appreciate it. We really appreciate this opportunity to be here today. I will go ahead and share our screen. Okay, can you see that okay?
Yes.
Okay. All right, and can you hear us all right?
Yep.
Okay. All right, so I'm Travis Jensen, and I'm here with a colleague of mine where we both work here at Meridian Engineering, as Mike Nadeau. So just kind of get started in introducing ourselves. I'm a professional land surveyor. I've been licensed for 18 years in the state of Utah. I'm also licensed in Idaho and have been for about 12 years. I recently had an ambition to go back to school and get my real estate license, since I'm so heavily involved in real estate type transactions as a surveyor. So I recently got my real estate license this last February, and have hung my license with Presidio, and so I'm excited to be here and be part of you guys. I am a project manager with Meridian Engineering. I mostly do a lot of consulting work for UDOT on their right-of-way acquisitions. And I'm an active member of the IRWA, or the International Right-of-Way Association. And excited to be able to share some of our experiences and knowledge with you guys to better help and support your clients.
Hey guys, so I'm Mike Nadeau. Professionally, I always put Michael on everything professionally, but if you call and need a survey or something, feel free to call me Mike. I'm also a professionally licensed land surveyor. I've been licensed for about 20 years. The one thing that Travis didn't mention to you guys was that Travis and I were schoolmates back in the late 90s, trying to be surveyors back in the day. So Travis and I have known each other for well over 20 years now at this point. So it's a good relationship, and he's a good worker here at Meridian as well. So I'm also a certified federal surveyor, so I had a little bit more training through the Bureau of Land Management to get that designation. That is more for the public land survey system, dealing with section corners and things like that. We're going to touch on that a little bit today if we have a little bit of time. I'm also an active member of the Utah Council of Land Surveyors. I'm the current chairman of the Western Federation of Professional Land Surveyors, which makes up the 13 Western states in the United States. So that's pretty fun. October is my last meeting as chairman, then I'll be the past chairman. But that's been a very good professional experience for me, and I really enjoyed that. I've got 27 total years of experience in surveying. I wanted to mention I'm also an adjunct instructor in the surveying programs at Utah Valley University and Salt Lake Community College. And so that was kind of one thing I wanted to talk about is the examples we're going to show today. I do the same type of thing in my classes. I don't like to just, show maybe this could happen or maybe that could happen. We like to bring real world situations to you guys, and I do the same thing with my students. So everything you're going to see today is like a real world scenario or real world situation that myself or Travis have dealt with, or somebody here at Meridian has dealt with. I'm also an active member of the Utah Council of Land Surveyors Standards and Ethics Committee. We can talk a little bit more about that a little bit after that. So that's me in a nutshell.
So with that, if anybody has any questions along the way, please don't hesitate to stop us and ask your questions. We want this to be an interactive discussion, so hopefully you've got some input. So here's just kind of a funny that we'd like to start with is we've got the 3 surveyors and the other guy. So it's kind of one of those funnies that Teddy Roosevelt was that one guy that didn't live up to the standards, I guess.
Sorry guys, survey jokes, you know.
So with surveying, it's a lot like any other professional organization or professional out there, like engineering or real estate or any of those. We're professionally licensed, and we are held to state regulations, code of ethics, just like any real estate agents and such. We are regulated by state code, and those are very precisely defined. And we have to, any survey that we do, we have to file that survey, and it has to be recorded with the county surveyor's office. So with that in mind, I know that as a real estate agent, we're going through the transaction process of closing on a property, and we involve the title company in that, and we get a PR on that parcel of land, right? The one thing that the title company does not look into and isn't a part of that report is any surveys that have been filed on that land or that parcel. So, and the reason for that is partially because those surveys are not recorded with the county recorder's office. And they're not necessarily recorded, they're filed as with the county surveyor. And so they're not, they don't go through the same review process, but each county surveyor does have their own kind of set of criteria of what they require on those surveys. And, as a company with Meridian, we have like 8 licensed surveyors, which puts us in a position to be one of the largest surveying firms in the state. And we have great relationships with all of those counties, and we are involved in projects throughout the entire state, which I think gives us an advantage to being able to service not only your clients, but all of our clients that need, and it gives us that experience that that each county or each area kind of has, and what has happened in those areas as far as like historical surveys and stuff like that. So with that, just one other note is, if you do file, I guess I'd be interested, hopefully there's people on that have had surveys done. But anytime that a survey is done on a property, it is state law that the surveyor has to file a record of the survey. And the reason for that is to be able to help perpetuate section corners, the monuments that are there, and to perpetuate those property lines, and give basically an accountability to the surveyor of what he did or didn't do. So as you guys order a survey on any property, make sure that you get a copy of that recorded survey, so that your client's paying for it. And if the surveyor's not doing that, then he's not fulfilling his responsibilities.
So if your surveyor is not doing that, feel free to let me know. I do sit on the Standards Ethics Committee of the Utah Council of Land Surveyors, and I have no problem calling up that surveyor and talking to them and finding out why they're not filing their record of surveys. It is state law, and Travis and I do know there are a few surveyors out there that are cutting corners and that are not filing their surveys. And we, as an organization of the Utah Council of Land Surveyors, we're trying to stop that. We're trying to get these guys up to the correct bar in the surveying profession. So along those lines, this next slide is actually talking about the minimum standards that we have set up as the Utah Council of Land Surveyors. It's easy to say, oh, well, I'm not a member of the UCLS, so I don't have to follow these. Well, that's not so true anymore. These specific standards, they were developed in 1999. We rehashed them and kind of redid them in 2010. So they're about 11 years old since the new one. these standards have been used in court cases on boundary disputes. So at this point, this is considered common law in the state of Utah, whether you're a member of the UCLS or not. As a surveyor in the state of Utah, these minimum standards are considered common law. And every surveyor should know about these, but I've talked to surveyors throughout the state that unfortunately not all surveyors know about these standards. So you know what, if you're shopping for your client for a surveyor and you're talking to a surveyor out there, ask them if they know about these standards. Make sure they're going to file their survey. Those are the high standards that Meridian holds all of our surveyors to. And we also expect the other surveyors in our profession to be holding to the same standard. And that just kind of keeps everybody on the same level playing field, right? So we just kind of we didn't want to spend a lot of time boring you guys with state laws and regulations and minimum standards, but we just kind of wanted to mention this to you guys so that you guys knew as you're talking to other surveyors for your clients, you know kind of the rules and regulations that are in place by the state of Utah for surveys, okay? And I was going to start here, right? Yeah. Okay, so we're going to jump right into the examples. This first example is literally a very simple lot in a subdivision. Okay, there's no issues. There was no problems with this. We went out there. You could see the monuments that we surveyed. There's right there in that cul-de-sac. There's a monument right in the center there. You can see the monuments up at the very top along the top of the page. Those are what we call section corners. And I know you guys have had a little education about section corners and quarter corners and townships and ranges. That is how this lot in a subdivision is tied to the world, tied to the ground, is these monuments. We need to go survey these monuments so we can figure out where the property lines sit. And then once we figure out where the property lines sit, we got to come back to the office, draft up the plat, and file this specific survey with the Salt Lake County Surveyor's Office. On top of that, we also set the property corners for the client because, of course, the whole purpose of this was a new build and they wanted to put a fence up. Brand new lot in the subdivision, they wanted to know where their property lines were. So really basic generic survey. We'll go through a couple elements here. If you go to the next slide here, here's kind of a blow up of the parcel itself. What we like to do is we will survey any permanent substantial feature that's on the property, and we will show that on the survey itself. So if there was a swimming pool in the backyard, I would probably survey that. If there was maybe like a connex or a movable shed, I'm not going to survey something like that. But if there's something that's attached to the ground that's staying there, I'm going to survey that and I'm going to show it on the boundary. And I'm actually, you can see we dimension distances from the property corners up to the home, right? This specific instance, the client can look at it and go, hey, I meet setbacks. We're good. The setback on the north line was maybe 25 feet. We're good because you got 26.7 feet. So this is the basic lot layout that you're looking at here. And then if you go to the next screen.
So just one thing on that. I know like in a lot of our classes, they really kind of try to emphasize the difference between real property and personal property.
Yeah.
So kind of the things that Mike's talking about are going to be more of those things that would be classified as real property, something that is fixed to the ground, whether it might even be a driveway, right? We might have a driveway coming here, and if the edge of the concrete is encroaching onto the neighbor's property, then we're going to survey that in and be able to identify and show that encroachment.
So I tend to get talking really fast. If you guys have questions or comments or concerns, feel free to just interrupt me just like Travis did, because I can get going on tangents. And so feel free to interrupt us at any time. Okay, so now here's the next part of the survey I wanted to show you. Again, this is the simple survey. By state law, we are required to show a surveyor certificate on the record of survey. My stamp or anybody's stamp here at Meridian needs to be signed through the stamp and dated. That's also state law. There needs to be a record legal description or a written legal description, and we'll talk a little bit more about written legal descriptions here in a second. And then it'll have a surveyor's narrative. The surveyor's narrative is literally controlled by state law. What goes in a surveyor's narrative is controlled by the 172317 state code, right? But the Utah Council of Land Surveyors minimum boundary standards expands on what should be in a narrative. Now, this is a simple lot in a subdivision, so you see that my narrative is not really big on this specific one, but I've actually had narratives that take up almost a whole page of just me trying to tell the next person who's going to look at my survey, what's going on here? How did this guy determine that east boundary line that's running along I-15? Things like that. I'm going to spell that out in my narrative, and that's going to perpetuate those boundaries for the future guy or the future landowners or the future sales transactions, things like that. We also at Meridian, we add survey notes. That's not state law. That's kind of a subjective thing that Meridian does. We like to have different notes depending on what the survey is and what we're doing. You do need a map and a legend. And then of course you need a scale bar and a north arrow. These are kind of the items that comprise a boundary survey. Now back to the record legal description. Of course, the record legal description is what you're going to find in the recorder's office. Travis is going to touch a little bit on why there would be an as surveyed legal description or a legal description that we as a surveyor would write for a certain purpose. So if you want to chat about that a little bit.
Yeah, so like Mike said, on the record legal description, that's going to be what you're going to find on the deed, right? So anytime that we see that warranty deed or that special warranty deed that gets filed when the transaction is completed, that legal description that's on that deed is what we're talking about for the record legal description. Now, in some cases, we will rewrite that description. We will write a as survey description. That is not necessarily going to take the place of the record description because we don't want to disrupt the chain of title. But what that as survey description will do is it will help in clarifying if there's any ambiguities in that record description. So for an example, if a parcel of land gets described, let's say in the 1920s, and that description goes through, 10 or 15 or 20 different transactions from when it originally started. And there was a typo, or maybe the next person didn't write, all the way out. Maybe they used the tax description instead. So there can be a lot of times a lot of ambiguities that get incorporated into that record description that doesn't completely describe where that property is. And so an as survey description will help to clarify and clean up some of those ambiguities. Another instance might be if there was a boundary dispute or a boundary problem between two parcels. Then we can go in and create that as survey description to help clarify what our findings are. And a lot of times that may get incorporated into a quitclaim deed or a boundary line agreement to help to further define where that property line is, especially if there was a dispute that the two landowners come to an agreement on, then we can help define where that new boundary line is, whether it's a new fence or an existing fence or whatever it might be, so that we can put into the county records what has been agreed upon, so that in the future, as those landowners move and we get new landowners, that we don't just recreate that boundary dispute all over again. So we're always striving to try to, once we resolve those, find ways to resolve those boundary issues, is to putting those things into the county records so that they're resolved for future generations.
I would also like to take this time to just kind of mention that Travis and I are under the opinion that we feel like surveyors should be the only ones writing these legal descriptions. I feel like the surveyor has the tool to determine, let's say, a record deed that you find on a deed. The legal description says 200 feet to a state road. And then we go out there and we survey it and we find out that the state road is 225 feet away. Well, that's our determination to make, and our opinion to say, okay, let's do a new legal description and say 225 feet to that state road. A lot of times you get attorneys, title companies, recorders' offices writing legal descriptions. And I kind of feel like that this should really only be a surveyor that's writing these descriptions, especially an as survey description, where there might be some sort of ambiguity that we're trying to resolve. Sometimes the title companies don't fully understand ambiguities in that nature. They also don't fully understand bases of bearings and monuments and where you're coming from. Those are the tools that Travis and I have learned over the last 25 plus years of our surveying careers. And that's why you want a surveyor to write these legal descriptions, not the title company, certainly not the recorder's office. We've seen a lot of errors happen out of the recorder's office with descriptions. So I just kind of wanted to put a plug in for that.
Does anybody have any questions or any comments so far?
I had a question for you, but it's more specific to land.
Okay.
There was a situation a few years ago where there was a fence line placed on a property and it had been there for 30 plus years. And the assumption was that after a certain amount of time, when there's an undisputed line that was established by a fence, that now became the new property line. And there was a big battle between the surveyors and the property owners. And is there a specific rule on that? And how do we handle that the best way if we come upon it in the future?
We actually have a slide about this, Brandon.
Awesome.
You are asking the correct questions. If you wait about 2 or 3 slides, we're actually going to jump into that.
Okay, perfect.
I can't remember the verbiage for it, but there's a term for it. It's considered acquiescence is what we're going to talk about. We're going to talk about that in a couple slides. So good question, Brandon. You're on the right track. I think if we're done with this one, we can probably move on to the next survey. Okay, so this is the second survey where, okay, problems are starting to arise. Okay, now this one, again, it's a lot in a subdivision. You wouldn't think that there would be problems arising in a lot in a subdivision, but it happens. So if you go to the next slide, Travis, I've kind of zoomed in on I guess it'd be the western, northwestern type corner of that survey that you were just looking at previously. What transpired here was, this is on Minuteman Drive in Draper. Minuteman Drive has been there for a long time. Okay, I think everybody, those of you that have been in the Solid Valley for a while know how long Minuteman Drive has been there. We all know that UDOT put in the Michigan U-turn there that's really complicated and not a lot of people like it. This is that same area, okay? Then a land surveyor came in and did this subdivision plat that's kind of here to the southeast, and he didn't, I don't want to throw any surveyor under the bus, his name isn't shown here anywhere, but he didn't do his due diligence. And he didn't do his due diligence in trying to find out where Minuteman Drive is. And Minuteman Drive is a state highway that has deeds associated to it. It has right-of-way drawings associated with it that are found in the Utah Department of Transportation's central offices. So if that surveyor had done his due diligence, he would have known exactly where Minuteman Drive was. Well, we get a client, they want us to do this survey of a lot of subdivision. Should be pretty simple. It's a lot in a subdivision. It adjoins a state highway. It adjoins a dedicated roadway to the west, east. So it shouldn't have been too bad. Well, when we get into it, we realize that the land surveyor that developed the subdivision plat left a gap between the plat and Minuteman Drive for UDOT. Okay, and so I can't, as a surveyor, I have to state the facts. I have to tell the client what is happening. I can't just assume, okay, well, this little gray hatched area is just going to be UDOT because lot 1 or whatever this lot is of the subdivision plat goes up to a certain point, and then everything northwest of that is UDOT. I can't say that. I can say, here's lot 1, here's the boundary for lot 1, here's Minuteman Drive, and oh, by the way, now you've got this sliver that has never been cleared up, and the owner is the developer of the subdivision plat. We actually went back and researched it to find out who owns the strip of ground. It's the developer from the subdivision plat. He has now sold off the lots in the subdivision. The developer thinks he doesn't own anything out there anymore, but lo and behold, he now owns a strip of ground that honestly, he's probably not even being taxed on because I don't think the county even knows that this strip exists. And gaps, I do want to say this, gaps in land rarely exist. There's usually an owner for a gap. You can, through a chain of title abstract or putting the puzzle together, going all the way back to the 1800s moving forward, more than likely a surveyor that knows what he's doing can figure out who owns that gap. This instance, we did our research and we found out that the developer still owns that gap. So really, the owners of lot 1 and this lot here to the south, I think it's probably lots 1 and lot 2, they don't own that gap. UDOT doesn't own that gap, but there's a problem here and it needs to be cleared up. And so all we're doing is stating the facts. Our client's not going to do anything about it, but I would suggest that UDOT try to maybe clear this up by quiet title action or something to that effect to kind of clear this gap up. So now we're kind of getting into issues in boundary surveys where you see, oh, maybe surveying isn't so, stupid simple. Just show me where my property lines are. Well, okay, I can show you where your property lines are, but don't you want to know the rest of the story? Well, here's the rest of the story in this situation. So I don't know if you have anything to add on that, Travis.
No, I think we're good.
Okay, if there's nothing on that, are there any questions on that? Because the very next item, it might take a minute and it's going to go into what Brandon was asking about. Okay, let's move on to the next one then. So I did have to put a note. This is not, this survey is not complete. We're still finishing it up, finalizing it. We've made our boundary determinations, but it's not stamped. So I'm just kind of throwing the whole, here's the whole plat. Again, this is a lot in a subdivision, guys. It should be easy. A lot in a subdivision, subdivision plats are considered simultaneous conveyances where meets and bounds, you have, 10 parcels up here that are meets and bounds. Those are sequential conveyances. In a subdivision plat, a simultaneous conveyance means John Adams gets lot 1, John Smith gets lot 2, Andy Smith gets lot 3, right? Those are all simultaneous conveyances that happen at the time of recording the plat. So you usually don't run into problems in lots and subdivisions, but now here's the second one I'm showing you guys where the problem is even bigger. Okay, so let's go to the next slide. And this is where you can kind of start to see it. And Travis might need to show you with this mouse, so it might make a little more sense. Okay, so starting on the west lot line, on that far outside line, we have the original lot line where Travis's mouse is right there, okay? That was the original platted lot line. So simultaneous conveyance, lot 8 gets lot 8, lot 9 to the west gets lot 9, right? Simple. Well, notice that the fence line was built a little bit to the east. There's a gap right there. The client for lot 8 told my crew chief out in the field, he said, hey, I got some stuff from the 50s, some exhibits. Do you guys want these? And we're like, yeah, we would love to have those exhibits. Well, there was an exhibit that was made for the west line that shows this new location with a fence, and they had recorded that exhibit in the recorder's office, and that legal description became part of the record. And so it was pretty easy for Meridian and for us to say, okay, that new dark line, that's the new boundary line. We're comfortable with that. It hits the fence. There's a recorded description in the recorder's office. We felt extremely comfortable here, okay? Now let's talk about the south line. The south line, the original lot line, is the dark line where Travis has his mouse there, okay? There's also an exhibit that was done in 1959 along the red line. And if you notice, it's kind of hard to tell, but you see the little squares or circles along the red line? That's the fence. So there's an existing fence going along the red line. So this is kind of going back to Brandon's question of, has acquiescence happened here? What's going on here? And what are the elements of acquiescence? And guess what? We're talking 60 years here, guys. I think Brandon mentioned something about 30 years where a fence has been in place. This instance, the fence has been there for 60 years. So did acquiescence transpire? Did you want to add anything more, Travis, before we go to the next screen? Okay, so let's go to the next screen. Oh, sorry, here's the exhibits. The one on the left is the one for the west boundary line. That's the one that was found in the recorder's office. It's recorded, it's good to go. The one on the right is the 1959 exhibit of the south line. It is not recorded. We searched all through the recorder's office trying to find this thing. It is not recorded. So there's an ambiguity, right? This is not recorded. The fence is in the location of the exhibit, and the fence does not match the lot line between lots 8 and I think it's 7. Okay. Oh, and just for a note, the subdivision plat was recorded in 1954. So if we go to the next slide, this is what I want to ask you guys, which is exactly what Brandon just asked. Did acquiescence occur along the south fence? One thing you guys, I don't want to delve in this too much. It's, because, you guys aren't surveyors, but you need to know that there was a 2016 Utah Supreme Court case. It was Q2 LLC versus Hughes, where acquiescence no longer needs to be adjudicated by a judge. Okay. As long as you meet these 4 elements, acquiescence passes by a matter of law. Okay. And those elements are occupation up to a visible line, a fence line, ditch, grass line, whatever you want to find out there. Mutual acquiescence to the line, meaning the 2 adjoining landowners mutually agree to that location. It has to be for a minimum of 20 years. Okay, Brandon's example, he said 30. Our example, we've got 60. And then it's by adjoining landowners. So one would assume that acquiescence has probably transpired on this example. But if we go back to that example, go back a couple there, Travis. If we go back to that example, you'll notice that I'm still holding the dark boundary line as the lot line. The reason being is because there have been multiple transactions in these lot owners over the last 60 years. There has not been a continuous 20-year time frame where you had mutual agreement by 2 landowners that that fence was the boundary, because they kept changing hands so often. As of today, the south adjoiner knows his boundary line is north of that fence. And of course, the guy for lot 8, he believes that the fence is the boundary line. So right off the bat, you don't have mutual agreement between these 2 landowners. So we, as surveyors here at Meridian, we chose to say acquiescence did not transpire in this instance because you never had the second or third element. I can't remember which element it was of the second element, mutual acquiescence to the line. We've never had that mutual meeting of the minds where those 2 landowners come together and say, yeah, that fence has always been the boundary and it's been there for 60 years. We don't have that in this instance. So it meets the other 3 items, but it does not meet item 2. So just be careful when you're talking with your clients and talking about possible acquiescence and, hey, a fence has been there for 20 years, so now it's automatically the boundary line. That may not be the case. In fact, when we're in school as surveyors, we are taught to talk to the landowners. If you see a problem, we're taught to go talk to that adjoining landowner and say, you don't want to ask them leading questions, though. You got to be careful, but you got to say, hey, do you guys know how that fence got built? Don't tell them the boundary line is 4 feet over the fence. Just say, do you guys know how that fence was built? And then as you're getting the story without leading questions, you start figuring out what's going on. And a lot of times, in my mind, if you feel like acquiescence has transpired and there has been that mutual acquiescence between the 2 adjoining landowners, I would suggest getting, you can transcribe these notes down and have the landowners sign in front of a notary saying that the boundary line is the fence line. Whether the fence line was the boundary or not, those 2 landowners are the only 2 landowners that can make that fence line the boundary. They're the ones that mutually agreed to it. I, as a surveyor, I'm just there to help them. I can't tell them where they think the boundary line is, even if it's not on the fence. That's their decision. And so you get their statements, and then you would also follow that up with an actual record of survey, and then you might do some cross quitclaim deeds or something like that to get it into the record so that the future surveyor 40 years from now, he can pull all the research and be like, oh, hey, Mike Nadeau already figured this out with the landowners, acquiescence happened, and it's all the boundary line's along the fence now. It doesn't matter that it's 4 feet away, but you got to make sure you clean it up correctly. You can't just assume, oh, the fence has been there for 20 years, so acquiescence happened, and that's now the boundary. That's not always the case. So I would caution you guys just to be careful when you're talking with your clients, not to just assume a fence is a boundary because it's been there for more than 20 years. It has to meet these 4 elements. And if it meets these 4 elements, well, then call me. Let's do a record of survey and clean up the record so it's fixed. And we can go from there, right? So did you have anything to add there?
Yeah, so a couple of things that I wanted to add with this, and then just go back. Did that help answer your question, Brandon?
Yes, but the follow-up to that would be, so then do you put new markers in?
Yes.
Because in the particular case that I was dealing with, there was no markers, and so they went with what the fence line was, and that was where the dispute really came in, because once the property owner found out, he's like, well, wait, I should have 8 more feet here, and that was where the dispute was, because there was no markers to begin with, and the fence was there, and when he found out, it just kind of erupted into an issue.
So in that instance, Brandon, it could have been that acquiescence actually had transpired, but because you get a new landowner in there and he starts disputing it, and that because it was never fixed by a surveyor or fixed in the records, the new landowner comes in and says, no, my property line's 8 feet over that fence. All of a sudden, acquiescence stops. So as soon as you feel like you have an acquiescence case, call a surveyor and get it fixed before any new land transactions happen. And all of a sudden you get a new landowner that, good fences make good neighbors. I've always said that. And this is an instance where, let's clean it up while we got the good neighbors that are working together before another landowner comes in. And that landowner, that new guy with the new transaction, he might be a nice guy, but he wants that 8 feet of his land. So yeah, definitely try to clean it up before it gets to that point.
Well, and it actually was, it was actually between the 2 neighbors that were there. One was getting ready to sell his property, and so he got the survey, and that's what really caused the issue. But
gotcha.
that's beside the point.
Gotcha. No,
okay, thank you.
We love talking about these things, Brandon. I could go on all day about this case specifically. So yeah, if you guys ever want to chat or go to lunch just to talk about fence lines and boundary lines, call me up.
So one thing about fences that I wanted to touch on is, wrong way. I want to give you guys a heads up on the next slide. One, when you're out there with your clients, and even though the property, I think through these examples we can illustrate, if we're out there showing a home and it's fully fenced, don't take that liability upon yourself by telling your client that the fences are the property lines. Because, in these examples, we can see that may or may not be the case. With that, part of that is we don't know what those fences were constructed for. Is there anybody on that was in my class last week that we talked about the 2 different types of fences that can tell us can remember what those were?
Nobody? Sounds like nobody was on last week, Travis. You got a whole new group.
All right. Well, there's 2 different types of fences. There's going to be a fence by, I just went blank. We've got a fence that's there for convenience, right? And we could have a fence that's literally like on the property line. So a couple things. First, with the fence that's on the property line. If we're in a brand new subdivision, well, really any subdivision, and we've got property corners set out there, and we want to fence our property, the number one and first mistake that probably 99.9% of fence companies and everybody else will do is they'll go out and they'll dig a hole right where that property corner is, and they'll pull the property corner out of the ground and they'll put their fence post in. I've seen it a bazillion times. It happened with me. My current home that I have right now, my neighbor put a fence in, and hired a fence company to come out, and before I could get home and get out there to stop it, they went out there, they pulled the property corner out of the ground and put the fence post in. That's what causes these types of problems. Our suggestion is dig a hole that's right next to the property corner and when you pour concrete around that fence post, concrete that property corner into it. And then it eliminates any future, any disputes or issues. The other thing that I wanted to talk about with fences is fences of convenience. Last week we talked about this, and what the discussion was is sometimes we really have to be careful about identifying a fence, because especially this happens a lot of larger parcels where we go out and we build a fence to put our cows in, or we've got a horse or some goats or something of that nature, and we just throw up a fence so that we can keep them from going onto the neighbor's property, right? So it's a corral. But maybe that fence just happens to be really close to the property line. Was the intent for that fence to be constructed on the property line, or was the intent of that fence to be constructed to keep my cows from going onto my neighbor's property and eating its garden? So in some cases, we have to be very careful to be able to identify what the purpose of that fence was, and that we're not falsifying the purpose of that and acquiescing to that fence when that's not what the original intent of that fence was. So this is, these are just examples of all the analysis that we have to go through as surveyors to be able to identify what is possession lines and what's actually out there on the ground that the landowners are using as their property versus what's in the county records. And we have to go through this analysis of comparing the two together and being able to identify where that property actually, the boundaries of that property really are. So again, just if you're having a fence built, or your clients are going to build a fence or anything of that nature, make sure that they do not pull those property corners out, because keeping those property corners in are worth their weight in gold. I had a neighbor years ago, went out and they built their home, had their driveway going along, and their northwest corner was there, and the neighbor hired a surveyor to come out and survey the property, and the surveyor went out there and they set another property corner on that corner, right? She calls me up and is like, something just seems weird. I swear this corner was there. So I went out there with my metal locator, and sure enough, the new surveyor had set the corner literally like 2 inches away from the original corner that was there, but it was just buried about a foot underneath the ground. Here again, just make sure that you try to, anytime that you know that those corners are there, even if you're not going to build a fence, go out there and pour a bag of concrete. A $5 bag of concrete from Home Depot can save a lot of money in a survey later on.
So just to kind of follow up with what Travis was talking about with fence of conveniences, we definitely need to be careful with fence of convenience. Fence of convenience are those times when they're trying to keep hogs in or cows in or horses or something like that, and it may not be on the boundary line. They can become a boundary line though when the boundary line itself, the two landowners aren't quite sure where the boundary line is, and they look at the fence of convenience and go, oh, that must be the boundary line. And it's been there for 20 years and they agreed to it. And again, you've got some acquiescence there going on. But yeah, fences of convenience are just that. They're fences of convenience. They're not on the boundary line. They're just there to hold livestock in or up along a ditch or something like that. So yeah. Okay, so as you guys can see, we're almost out of time. I've kind of set this PowerPoint up to where the boundary issues get bigger and bigger and bigger, okay? This is one of the bigger ones. It's not the biggest one I've seen. I've seen a couple 100-foot busts before. This one, so let's just start with the picture. I've got a great field crew. I got 4 field crews. They're great guys. I mentor them. We have mentoring every single week. We sit down with them and We just go over a different topic, and I've just really got some good guys. And so this guy, he's my senior crew chief. He went out there and he found a stone, and you guys can kind of see the stone. I'm pointing to it. That is an actual original monument set by it was actually the GLO back in those times, the Government Land Office, which turned into the BLM, Bureau of Land Management. They would go out there and they would set, there was different things they would set for these section corners, but this is an instance in Utah. You find a lot of these in Utah where you find a stone rock that the federal government set saying, here is the section corner, okay? And Travis, you kind of wanted to touch on the stone itself.
Yeah, so I don't know if you can see this, but here's the stone, and you can see a 1/4 carved into the stone right here. So there's the 1, here's a line going across, and then here's the 4. So that would be a 1/4 corner stone monument.
And the research I did, we believe, if I remember right, this came from the 1880s. So the GLO came through in the 1880s in this area. This is up in Wanship, Utah, near Wanship, Utah. And they set these stones every half mile, right? You got the section corners that make up the full mile. And then in the midpoints, they put these 1/4 corners. That's what this is. So if you go to the next great slide, you can see one of our trucks sitting there. And I didn't get a picture of the other monument because it has the other surveyor's name on it. I don't like to disparage other surveyors, even though this guy really screwed up. You can see the orange point where Travis has his mouse. That's where the original 1880s government land corner is, okay? 35 feet to the east is a brand new fence and a property corner, basically a rebar and cap at the base of that fence post, where the surveyor is saying, here's where the 1/4 corner is, and he mathematically positioned it at that location from the 2 section corners a half mile north and a half mile south. So mathematically, he's 35 feet in the wrong location. He pounds in a rebar, and the landowner builds a brand new fence to that location. Guess what, guys? That surveyor, he could have just got himself in a major lawsuit because 35 feet west is the original 1880 stone set by the federal government. And whether that location is right or wrong, mathematically, it is correct. You have to use it. That is what all the land is tied to in this area, is that monument that's by that orange lath 35 feet away from the brand new fence corner that some surveyor wasn't paying attention to. And literally, the other surveyor had to park his truck where my surveyor parked his truck, walked over the 1/4 corner stone monument to put his rebar in 35 feet to the east, right? So these are the kind of issues that we see a lot of, unfortunately. And if I could put a plug into Meridian, we've got eight professional land surveyors on staff, and we do our best to try to not let stuff like this happen because, you know, don't get me wrong, nobody's perfect. We all make mistakes, but we do our best, and we have a big QC process. When we do surveys like this, we do our best to put those boundaries where they really are, right? You don't want to see a 35-foot error like this because I guarantee you that fence wasn't cheap. And the guy who did the survey probably charged the farmer there, you know, I don't know, $8,000 to survey this section of land. That's just a total guess, but I don't know how much that surveyor charged him. But he's wrong, and he's 35 feet wrong, and that's a big bust. So I don't know if you have anything to add to that. That's pretty much what I wanted to hit there. Are there any questions from you guys on any of those boundary issues, or Travis is telling me we're out of time? But yeah, we
I have
are.
a question. I have a couple of questions. So this is all new to me. Who's responsible to put the cornerstone there, basically, the marker?
So the federal government set it. Here in Utah, most of Utah, except for the mountainous areas, they were set in the 1800s. Here in this valley, they were out here in the 1850s, actually, right after the pioneers came in. So the federal government controlled the location of that monument. As Utah became a state in 1896, that got turned over to the county. Okay, so the county surveyor is who controls that monument today. But if this was on federal ground, US Forest Service land or BLM land, that would be still considered federal domain. But this specific monument is not in federal domain. It's considered it's controlled by the county surveyor in this location.
How does a mistake like that happen? I mean, what?
The surveyor did not do his due diligence, and he didn't find that stone monument that was set 140 years ago.
They just randomly guess? What?
No, he didn't. The problem is he didn't do his due diligence to find it. And so what he did was he found the monument a half mile north,
Oh, that's right.
half mile south, and then he mathematically proportioned the midpoint. And then he set a rebar and camp there. And you can tell north-south, his measurement was pretty good. East-west, his measurement was off by 35 feet. And so this is an instance where that surveyor held math over the actual evidence in the field. So that's really how that's how the error happened.
Okay, so just to clarify, going back, so when the surveyors mark the property, you suggest digging a hole and putting concrete there, but they only put flags, right?
We actually put that flag up. We found that monument and flagged it up like that.
Okay.
The other surveyor didn't find it.
Yeah, and so as far as like your property corners, so if you're in a subdivision, whoever the surveyor is, so when a subdivision plat is recorded, the actual subdivision plat is generated by a professional land surveyor. So he's actually going to be the one that's going to create all of those lots and all of those boundaries for those lots, and he's going to stamp and sign it along with any of the city or county officials, right? And so that's what Mike was talking about. When that happens, that's a simultaneous conveyance. And so all of those lots are created at the same time. When he does that, he's going to also, as part of that, his responsibility in that subdivision plat is to go out and put property corners at each angle point or each actual corner of that lot in that subdivision. So those are the ones that I'm talking about. If you're in a subdivision like that and some surveyors come out there and mark those, do your best to make sure that those don't disappear, whether that's putting a T-post next to them, pouring some concrete around them, just something to secure that monument so that it doesn't just vanish or get pulled out of the ground really easily.
So one last quick question. So if you're in an established neighborhood that's like 30 years old and you don't have an actual fence up, but you have like a stone fence maybe, and your property, you know, you can go in and question and get your map and see if those stones were put in the proper place. And if they're not, you can ask that they be moved, or, I mean, I know that causes maybe neighbor problems, but do you know what I'm saying?
In that instance, Mary, if there's some either disagreement or some ambiguity, what you see out in the field like that between two landowners, I would suggest that you suggest to them that they get a survey done. That way, once they know where that boundary line is, they'll know if that stone wall is on the boundary line or not. So that's my suggestion, is to get a survey done.
So get a new survey done. Okay.
Yep.
All right, thanks.
Yep. There was somebody else that had a question. I didn't see who it was.
Guess not. Guess we're done.
Okay. All right, well, we appreciate you guys' time today. I hope that this information was beneficial for you. We hope that we'd like to be able to have more of these types of discussions and talk about other things that obviously surveying is a pretty complex profession, and there's lots of different stories and examples that we can share and different things that we can talk about. So hopefully that we can be able to have more of these types of discussions and talks.
Well, and if you guys have any issues with your clients today or things that might come up in the future, feel free to call Travis. He's one of the surveyors here at Meridian, and he's a good surveyor. he does his due diligence, and I know you guys know him. He's probably on some list over there, Presidio. Feel free to give him a call, bounce questions off of him, and if it is determined outside of that conversation or inside of that conversation that you guys need to maybe do a boundary survey for your client, he can easily put a scope and cost together to figure that out. But ultimately, sometimes the best answer is just get a surveyor involved so you know where the boundary lines are. Okay. Thanks, guys.
Thanks for being here with us. Thank you. Appreciate you guys. Have a good day.
Thanks, guys.